All right, good evening, everyone. This is a special edition of Wicked, Women in Canadian Criminal Defense, and our YouTube channel. We have a special episode that we wanted to bring to you as close to the decision as possible from the Hockey Canada case that just came out in London, Ontario, so that we can help hopefully both educate and also illuminate some issues surrounding the trial, surrounding the decision, and help the public understand how it is that we got here, why it is that EM and her version of events was so closely scrutinized, and why that is important in criminal defense and when someone's charged with criminal charges, because we of course want to make sure that they have the right to a fair trial and that they are having their guilt proven beyond a reasonable doubt, which is the Crown's onus to prove. Because otherwise, what we all are concerned about in our society is the potential of wrongful convictions, and this idea that you could just be charged with something based on someone's word and then have the key thrown away on you and you're locked up without any due process. That can't be the answer either. And so this video is really meant to try and help educate and inform and hopefully start a discussion. And we, of course, encourage healthy debate. We understand that these conversations can be difficult for a lot of people. We understand that everyone's going to have differing opinions on this, and we respect that. We just hope to add to those conversations. So with me today, I have a number of people, really fantastic, brilliant criminal defense lawyers from across Ontario. Hamna Anwar is with us. Hi, Hamna. Hamna, how are you?
Hi, I'm good. Thanks for having me, Cassandra.
Good, thank you. Maria Rosa Muia.
Hi, thank you for having me. I'm so glad we're having this discussion.
Thanks. Megan Delaronde.
Hey, Cassandra, thanks for having me.
Okay. And Natasha Calvinho.
Hi, Cassandra. Thanks for having me and including me in this very important discussion.
Of course. So, ladies, I'm going to turn to the group and I'm going to ask someone to jump in and help us understand the facts. And so let's go back to the basics. Let's go back to what happened. What did the judge hear? What was the actual version of events that the court heard that led to ultimately the decision?
I can start us on an overview of the facts here. So we're looking back into 2018, so a number of years ago, that a young woman, she's identified as EM, reports to police that she was sexually assaulted by a group of men. The police look into these allegations at the time. Some of them are spoken to, not all of them are spoken to, and the decision is made that charges aren't going to be laid. A number of years fast forward, and this complaint is taken to Hockey Canada as a civil lawsuit. This civil lawsuit is dealt with by Hockey Canada without the knowledge of the young men who are accused of the wrongdoing. They are all, after the fact, very consistent that they did not become aware of this suit until after it was settled between Hockey Canada and EM. But it's after that that it comes to light and gets picked up by the London police that perhaps the investigation that was done wasn't as sufficient as it could have been back in 2018. And so new officers are put on the case and they take a look at the reporting that was done at the time to the police. They take a look at some of the new evidence that's coming out and they decide that they're going to lay charges from there. And so the altercation that's at issue is EM says that she is out for a night at Jack's Bar in London where she meets Michael McLeod, one of the five who was charged. Over the course of the night, she's drinking, she's dancing, she's talking with various people at the bar, and she ultimately comes to the decision that she's going to go back to Michael McLeod, or go back with Michael McLeod to his hotel room and engage in consensual sex. After that is where we start to get differing versions of what happened from the various people involved. And one of the things I think that other members here are going to touch on later is that throughout the various versions that EM gives of this night, the story is going to change a little bit. The details are going to start to differ between some of the different accounts, but ultimately, some of the information that comes out that seems to be consistent between various people is that a group of all of these boys, approximately 10 of them shifting throughout the night, come into the room, engage in various sex acts with EM, and leave. EM leaves in the morning. She's not quite sure what happened. She knows that she was drinking a lot, and through talking with some other people, she decides that she's going to report what happened to the police. The controversial, maybe I should say the controversies of the case that seem to have been at issue for the judge and ultimately what this case was hinging on is what was the consent or lack thereof that was communicated to all of the boys who were involved in this. Did Michael McLeod have the consent of EM to invite the other boys into the room? And did all of the other boys who came into the room have the consent of EM to be engaging in the various sex acts that they were engaging in with her? Very important to this decision and to the end result that we get to. I understand that the decision that Justice Caracia wrote, the judge in the case, is going to be published or is already widely available. But in this decision, I think very crucial to where we find ourselves today is that EM says at various times that she took on this porn star-like persona. And she ascribes it to she was in fear for her life. She was in fear for her safety. The only thing that she could do was put on this provocative persona, acquiesce to what was being asked, and tried to get out of the room. Ultimately, of course, as we see, that doesn't end up quite being accepted by the judge, as we're going to talk about. And of course, the boys are saying from their side, we don't think it was a persona. We were under the impression we had her full consent to be engaging in these sex acts. So it's kind of a blanket overview of the facts.
That was really great. Thanks, Megan. Yeah, I think what I'm struggling with is when I speak to people about this, lay public members and, you know, friends, family of my own, they don't understand the factual matrix of what happened, even from EM's own perspective sometimes. And so, for example, she acknowledges or appreciates in cross-examination at times that she may have even been seen to be initiating certain things. She appreciates and acknowledges at certain times that it may have seemed that she was consenting. And that's the really gray area here that I think this case, why this case is so different than some other cases that someone might have in mind, where it's like a very clear, she was not saying yes, and therefore, you know, there should have been very clear signs that this was not wanted or consensual touching. That's not what was happening here. And I think what the Crown was really trying to do is push the envelope on the definition of consent, which is, you know, this is why they had a piece of the argument was about whether her consent was vitiated, because the argument goes basically by the very nature of the fact that these men were tall and, you know, muscular-ish. They were 18 or 19 at the time, let's remember. Definitely bigger than EM. And then because there was multiple of them, that fact almost in and of itself meant she couldn't have consented. And I think that's a myth and stereotype as well, too, that we need to be careful of, because if we want to, as women, understand that we are sexual beings and that we have sexual freedom to choose, I think it's just as dangerous for us to say that a woman could never consent in that situation. And so that's, I think, where, you know, when we're talking about the facts of this case, people really didn't understand even that much, that there were certain pieces of it that the judge had to contend with, that the judge had to, you know, think about in coming to her decision. Is there anything else that I'm missing or that Megan's missed that someone wanted to focus on?
No, I think that was a very high level summary of the evidence that and how it came out.
Hamna, over to you.
Yeah, I just wanted to point out that this case gained a lot of media attention, and the issue of consent was really flamboyant because the consent video, so to speak, became really famous, and people thought that this is a nuanced legal issue that Her Honor would be dealing with. And really, Her Honor dealt with the videos in a very limited manner. In fact, as we saw in her detailed reasons of judgment, that she actually used it to assess the demeanor of EM and assess her level of intoxication as well as fear. So the videos, as we know, the law of consent has to be given prior to the act, during the act, and has to continue. So this idea of the consent videos, I think there's misunderstanding about what consent means, and Her Honor dissected that with her sort of analysis of credibility and reliability. And I think that would be helpful for us to dive into a little bit deeper.
Yeah, that's a great point. So exactly, there was a lot of discussion about consent and consent videos and, you know, after the fact videos of consent. Of course, that's not in and of itself proof that she wasn't at the time consenting. But to Hamna's point, there's a lot in law that we have to look at, or we have to consider, that you don't look at in the nitty gritty in the real world, or if you're just talking about it with your friends, right? You have to remember that a lot of these types of charges happen in closed quarters, behind closed doors, where there was only two people that were present. And in this case, you know, multiple people, but it's not like we have a recording of the actual events from that night to look at and objectively try to assess. And so judges have to use their best, you know, experiences and resources and their knowledge and their expertise to try and decipher from different people's evidence what actually happened. And in this case, she had multiple people to pull from, including men that didn't get charged, who, you know, right from day one were saying similar things, that EM was asking for someone to come and, quote, fuck her. She was also, you know, egging on some of the men, calling them pussies for not wanting to have sex with her. And in addition to all of that other objective evidence that the Crown called some of it themselves, interestingly, but then also that the defendants were able to rely on and point to. The judge, of course, was looking at EM herself and what objective she could look at that EM was doing or saying. And probably in that way, the best evidence was the Jack's videos from the bar, the video from the hotel of how she was walking, and then the video of consent after the fact, which again doesn't actually speak to the issue of consent so much, but it does help the judge understand her demeanor, how she was behaving, and allowed her to compare that to what EM was otherwise saying, which I think the judge essentially came to the conclusion that EM exaggerated quite a bit. Her level of intoxication, for example, she doubled how much she thought she had to drink. She was claiming that she was stumbling and falling over drunk, when in fact she was wearing very high stiletto heels and walking quite gracefully. The fact that at the hotel she was walking still well, even though she claims that she was completely out of it, to use EM's words. And so, you know, when you look at the actual objective evidence, and that is the most objective that you can get probably, is this video recording of the night of, compared to what EM is saying, that's where the judge is saying it's not quite adding up for me, right?
Sorry.
And that's, oh, I was just going to say something if I could. And that's the key part. And I think what you were saying, Cassandra, earlier is that, you know, what's missed by a lot of people perhaps is that these offenses do typically happen behind closed doors without witnesses, without other civilian witnesses. But in this particular case, there was independent evidence, being the two videos. So I think it's even more difficult, I would think, for a judge to assess straight he said, she says. He said this didn't happen. She said this did happen. He says that he had expressed communicated consent. She says that she didn't. But then when you have a situation where you do have videos that either corroborate or contradict what a witness is saying, particularly, like you said, Cassandra, with a level of intoxication, ability to walk, ability to communicate, then unfortunately what that does, unfortunately for the complainant, for this case EM, is that discredits everything else that you were saying, right? Because if you're untruthful, or if you're stretching the truth on, or misremembering points A, B, and C, then how is the judge going to be able to find beyond a reasonable doubt D, E, and F?
Yeah.
So
Megan,
in terms of a truth-seeking function, it was good that the videos existed.
Yeah, absolutely. Megan, did you still want to jump in there?
That's exactly what I was going to say. This case comes down to a question of EM's credibility and reliability. And those are words that you hear very often when it comes to the cross-examination and to considering the evidence of witnesses, particularly when the crime portion of what's going on isn't captured in video, in audio, and whatnot. And credibility and reliability are two separate analyses. We can think of them perhaps as credibility is, are you, and I'm framing this very, very roughly, are you worth believing on what you're saying based on what you're presenting is your credibility. Your reliability is, what are the external factors that may have influenced your ability to recall and communicate what you experienced. And so there's been some online discourse about the Jack's videos and what happened at Jack's in terms of the amount that she was drinking, the dancing, the touching of Michael McLeod's crotch, the behavior that went on there. And I've seen a lot of discourse online about, her behavior at the bar has nothing to do with whether or not she was sexually assaulted. You can drink lots and still be assaulted. You can dance provocatively with someone and still be assaulted. And that's all very true. That actually wasn't the issue that was coming out of the Jax videos, whether or not her dancing, dirty dancing with Michael was, therefore representative of what she wanted at that hotel. The amount that she had to drink was representative of what she wanted to happen at that hotel. That's actually not correct. The issue with Jax is she gave evidence about what happened at Jax, and that's not what happened on the security video. And so her credibility is being called into issue here. Are you actually telling us the truth about what happened in the hotel room? Because we can see you're not telling the truth about what happened at the bar. And then her reliability comes into question of, you had a lot to drink that night. And so are you accurately able to remember what happened in that hotel room? Because we can see you're not accurately recalling what happened in the bar. And so that's where the Jax bar becomes really important to Her Honor's assessment of EM's reliability and credibility. Again, not for her own intrinsic behavior in the bar, but for her inability to recall it correctly to the court in light of video that shows that her testimony about the bar was not correct.
Yeah, that's great. The other thing about her intoxication that does definitely sink into Her Honor's decision about the reliability piece. She comments on how I think she finds that EM wasn't so drunk that she couldn't consent. That's very clear. But she also says, it's a spectrum. So you can go from very sober to, blackout drunk. And it wasn't that EM was over here, but because she had drank something, it puts her over here a little bit, which does also impact her ability to properly recall the evidence or recall what happened. And that's also what we're talking about when we talk about reliability. And so, of course, EM herself talks about the gaps in her memory. EM herself says oftentimes the words, I feel that, or I think that. And Her Honor was concerned about that because in conjunction with EM's use of my truth versus the truth, it gave Her Honor the impression, who, remember, was sitting there very closely for several days listening to EM's testimony. It gave Her Honor the impression that perhaps it wasn't the objective truth, though. Perhaps it was EM's, best ability maybe to try and recall things, but it was tainted over time. It was tainted because of alcohol. It was tainted because she's got other things that have happened in between, including this lawsuit, including other interviews, including already being challenged over time. And what we see is a bit of a shifting narrative as well. So at first it was, I was so drunk I couldn't have consented to anything. But then the reason the case was closed the first time, as I understand it, is because the objective evidence that we've already talked about, the surveillance videos and stuff, tend to discredit that. And so then the narrative shift to, well, I was fearful. Well, this idea of fear never came out until 2022, 4 years later, during the Hockey Canada investigations, right? And so that's the narrative with which the Crown really proceeded with their case this time around, was her consent was vitiated because she was fearful and she wasn't actually consenting. She was just too fearful to say anything. Well, the problem is EM herself doesn't say that for 4 years, right? And listen, we all know about trauma responses. We understand that there is so much more to being a victim of sexual assault than you could ever understand fully in a quick YouTube segment. That's not really what we're trying to get at here. But the point is that it is one more thing that the judge has to go, I wonder why that narrative shifted. Is that a trauma response, or is that because I need to be careful here that maybe there's something else at play, right? So I think what we can do is move into the analysis a little bit. In short, we've already been touching on a lot of the things, but Her Honor finds that EM is not credible or reliable enough to hold beyond a reasonable doubt that the Crown has proven their case against that standard, meaning beyond a reasonable doubt. And so for lay people, for those in the public, if we were talking about a balance of probabilities, that's civil law. Like if you sue someone over a fence and who's got to pay for the fence, you have to prove 51% that you are in the right versus the other person. That is a much lower standard compared to criminal law, where beyond a reasonable doubt, if you've got a judge with good reasonable doubt a healthy dose, we call it, of reasonable doubt, you're looking more around the 80 to 90% range, I would say. So we understand that judges cannot ever know something 100% unless, of course, it's caught on video, and then maybe, right? But it's very hard for a Crown to prove something to 100% standard. That is not the standard. There is still room for some doubt. It can't be a reasonable doubt, right? And that's where Her Honor finds that she just cannot rely enough on the evidence of EM. One thing I did want to comment on as well, and maybe someone else can pick up on this, is, and this will shift a bit into the conversation we wanted to have here as well, about the role of defense lawyers in sexual assault trials. This was a very unusual case, not just because of its high profile nature, the notoriety of the hockey players and all of that, but because there was 5 of them. I mean, it's not typical that you have more than one accused person in a trial. And so it's also not typical that you then have 5 defense teams questioning someone, the same person, for days on end. And I appreciate why, for the public, that in and of itself was really concerning, that she was up there for so long, and it just kind of felt like an attack on her. But again, I go back to, that is the system. There has to be an ability to challenge the evidence. There was absolutely nothing wrong at law about that. That is, in fact, the way that it has to be, is that every accused person and their legal team get the opportunity to cross-examine the complainant making the accusations against them. And also the fact that it went on for so long, I want to be very clear. I actually was present personally. I'm from London, Ontario, for those that don't know. I was personally present in the courtroom for much of the evidence of the complainant. Not all of it, I will be fair. I have my own trials going on, but I would sneak in whenever I could. And she was at times giving very long-winded answers, which to me, they could have been much shorter. They could have answered the question and been more directly answered. That also caused delay in the length of her cross-examination. And so to say that the lawyers were kind of bullying her or ganging up on her, and that added to the unfairness of it, I hear that argument. I understand why to the general public it felt that way. But there was lots of different things that caused it to go on for so long. And the answer is not, well, they should only get, one opportunity or one day or something like that to ask her questions. That just would not have been doing justice to just how much was at stake here, which is 5 individual men potentially going to jail for, if you're found guilty of a sexual assault right now in Canada, that's probably at least a 2 or 3 year sentence, right? There's a lot on the line for these people. And so, yeah, I understand that a few days on the stand must have been grueling for EM. And I understand the courage and the determination that took. Thankfully, I also know that she had a really great support team. She had her own counsel present, who I saw during the trial. She had her own family members supporting her, which is great. But that doesn't take away from the fact that it is still required. It is a necessity of the trial process. Does anyone else have anything to add on that subject?
I was just going to say that I think it bears remembering that, yes, it's difficult, and she's presumed, or she's the EM is the alleged victim in this particular case, but it is those 5 young men. They are the ones on trial. So it's not so much about, as harsh as this is, about a fair trial for the complainant. This is not the complainant's trial. This is Mr. McLeod and the other 4 gentlemen's trial, right? They are the ones that, if they don't receive the fair trial, that they are going to custody. And so it takes as long as it takes. As a defense lawyer who does, I do quite a bit of sexual assault defense work. We're tired. We don't want to be standing up there for days on end asking a witness questions either, right? But sometimes we're not getting responsive answers to the questions that are being asked, and it's simply going to take the time that it's going to take. And and I might be tired at the end of the day, but we have a job to do, and I'm going to ask the questions, and I'm going to properly defend my client. It must be difficult that there were 5 defense lawyers, but we have to also consider that it is the Crown, not the defense, who decides how to prosecute this case. They could have chosen to charge these men individually, right? 1 trial, 2nd trial, 3rd trial, 4th trial, 5th trial, in which case it would have been perhaps more fair to EM, or easier for her in the sense that she's only being asked the questions by 1 lawyer at a time, but she's going to have to come back and testify 5 different times as well. So that's not going to be an easier process for her. And I bet you, if you added up the court hours, how long she was on the stand for 5 different trials versus 1, it would have been a lot longer. So
Yeah.
I think this was the fairest way to do it with that number of accused and the one alleged victim or complainant.
Yeah. I want to move now into a subject of doing defense work. I mean, anytime a trial like this comes out, we remember Jian Ghomeshi about a decade ago now. We now have this high profile sexual assault. We can think of so many others in the US that happen. The role of the defense lawyer starts to get questioned. And for an organization where we pride ourselves on women who do this work and gender non-conforming folks who do this work, this question probably unfairly gets posed to us more than anybody else. And so, Maria, maybe I'll turn to you. Can you help give us your thoughts on being a woman, doing defense work? How do we make it all work? How does that look?
Absolutely. I mean, it's definitely difficult. Being a lawyer in general is difficult. I think being a criminal defense lawyer makes it even more difficult. And when you add the layer of being a woman, it's a whole separate ballgame because we are scrutinized a little bit more as well. Being asked a question that I'm sure everyone gets is, well, how do you defend people like this? How do you defend people charged with, sexual assault? And I'll talk obviously about that one, but I think people need to remember that we are not a judge. We are not here to judge people. We are here to defend people. And as our jobs, we're not here condoning crimes, but we're just defending the constitutional right that every person in this country has. And so we don't pick and choose clients out of convenience. We don't pick and choose clients based on whether we think that we like them or like their cases. We provide, a zealous representation of pretty much anyone who comes into our office asking for our assistance. And I think where it gets very difficult is having to include gender. I don't feel that gender should really be much of a conversation. It shouldn't matter if you're a woman or you're a man in this profession and defending a certain type of case. At the end of the day, the fact of me being a woman does not change how I defend someone's case. It doesn't really change the questions that I ask a complainant in a sexual assault trial. And so what I think is very difficult is people using gender essentially to further their views of why they think crime is bad or why they don't like a certain type of case. And I think what we've seen in particular with the current case with EM is that, I'm sure a lot of people are not very happy with the ultimate decision. And they're also looking at the female defense lawyers that were on that team and trying to say, well, they're hiding behind female defense lawyers. That's why they won. And I think that's very unfair and it discredits the hard work of every single woman in this profession.
Yeah. There's 2 points I want to make that you've raised, and I'll just kind of pick up on. One is being a female defense lawyer means that we've probably had to overcome our own prejudices and stereotypes against us over the years. And so typically I find that women lawyers are usually the smartest people in the room because we have had to work so hard, and we are like the top, the best of the best, because we didn't just get the opportunities handed to us. We really had to work for them, right? The other point that I'll make is that when I answer that question for folks that ask me, to me, I always say, like, they say, doesn't it bother you defending someone that you know or that you think is guilty? And for me, the answer is actually, no, it's scarier to me, or it weighs more on me when I'm afraid that I've been trusted with someone's fate and they're innocent, right? And those do happen. Those people do walk through our door. And I've represented a number of people who, again, based on the evidence that eventually gets presented, I am confident that they were objectively wrongfully being accused, right? A lot of people assume that if police lay charges, that means that it must have happened. And that's just not true. There are so many times that as the evidence plays out, it turns out that that was only maybe even a portion of the truth, if not a complete fabrication. And there was so much more to the story, right? So that's what really scares me. And there's an old saying, we'd rather see 10 people go free who did it than one person who's guilty be wrongfully imprisoned or wrongfully convicted. And that's kind of in keeping with what I'm saying. I would I'm much happier being the link or the professional for someone to a criminal justice system and helping them understand their way and navigate their way through the system, even if they are guilty, than to not be there for the people who need us, who are innocent and otherwise are facing the weight of the heavy-handed criminal justice system. It's the strongest, bluntest tool our society has. We need to protect against that.
I think
Go ahead.
Yeah, I want to say, like, any of us who do this job would take great pride in doing it because it's a very, very tough job to do. And it's insanely difficult for women to stay in this job. We have a huge retention issue with women. And as we all mentor a lot of young women who come through the doors who want to be criminal defense lawyers, they leave the field for various reasons, including the fact that, there's a lot of pushback and challenges we face as women in the courtroom with their clients initially. We have difficulty. We don't lose power when we walk in a courtroom. So all of these skills we have to learn on the job, as well as the legal skills we need to have to do a good job as a lawyer. But at the end of the day, knowing that the public may think that we may be doing this for one reason or the other, not the real reason why we're doing it, it's just very disappointing. We are very much care about our clients. I remember my last jury trial, I even considered taking out my nose ring because I just didn't want the jury to make anything of me and indirectly of my client. Like, that's how much we think about our cases and our clients. And just to assume that, we're showpiece for our clients or we don't have any value add other than the way we might look, it's quite disappointing. And I think the general public needs to know, like, how much value we bring to the profession.
Yeah, we bring a
Not-
softness to the profession. Sorry, Megan, if I can just add, like, we are not traitors to our own gender. Like, we, in fact, I think the more women enter law in general, but especially criminal defense, we bring a softness and an empathy to the job that people forget. Like, I don't think most women would rather be cross-examined by a man than by a woman. Maybe I'm wrong about that, but when I go into a cross-examination, the one thing that I know is that I am going to be so much more respectful, probably just based on my own experiences and my own understanding of subconscious bias, than a man who has never had that lived experience, right? And so at least I hope that I'm able to offer that in my role, in my doing of this job. And there's probably complainants who have cross-examined who would disagree, and that's their right. That of course, I've never been in that hot seat like that, but I really do think, as an overall proposition, we bring a softness and a caring component to this work that was much needed for many, many years. Sorry, Megan, I cut you off.
No, not at all. I think we've also, we've talked a lot about the care that we have for our clients. I think it's also important to touch on the care that we have for society in general. And I think that there's a lot of reporting that gets done that, defense lawyers don't care about what these kinds of decisions mean for sexual assault survivors, for the broader public and whatnot. So many defense lawyers that I know and in the work I do, we are supremely concerned with how the cases that we are a part of are going to affect people in the future, right? The decisions that come out of our cases at the trial level, at the appeal level, those impact people going forward. When police have breached people's rights and we are fighting to have that acknowledged, that doesn't just impact the client that we have in front of us, whom society might find reprehensible for whatever reason. That affects the broader society so much more. It affects every person watching this. It affects everyone. Your rights to exist in the society in a peaceful and democratic, in a non-police state, is in part due to the work that criminal defense lawyers do every single day to work to preserve your rights. And so we are supremely concerned with how this affects society. There are many criminal defense lawyers who are involved in initiatives to try to work towards better justice solutions for people who have been victims of and charged with sexual assaults. For example, there are many defense lawyers who are tirelessly advocating for non-criminal court reconciliatory initiatives. And unfortunately, it is some of the, the Ministry of the Attorney General that is at times actually resistant to allowing these kinds of reconciliatory processes, even where complainants themselves are desperately begging for that kind of resolution. And there are many defense lawyers that are trying to work towards those kinds of reforms. And so I think that, acting as though women are this homogenous group that are bad or immoral as a whole for engaging with these kinds of cases takes away from the work and the care and the blood, sweat, and tears that we put into not just defending clients who must have their rights upholded, but the outpouring that gives into society that is incredibly valuable.
Yeah. I don't know if
And
you
if
guys caught, but Megan Seavard gave a short commentary to CBC or to everyone, I guess, to all media that was public, after the decision. And she said that on behalf of her client, Carter Hart, he wanted to engage in reconciliation type outcome here. He wanted to do something other than this very public trial. He was left with no choice too. He had no choice but to defend himself. And he tried, it sounds like him and his lawyer tried. And so, you know, when you blame the defense lawyers for questioning EM for so long, you have to remember in the back of your head that the Crown also had other options and chose not to do that. Right. And so it's not just all on us. Sorry, Natasha, I cut you off now.
No, that's okay. I was just going to pick back up on something Megan was saying. And I think that, there's a mosquito. I think that concept is lost on a lot of people, that it's not just about this case. This case is not just about Hockey Canada. This case is not just about EM. It's about what those principles down the road do. So every case that we do, hopefully, has a positive impact one way or the other on police conduct, Crown prosecutorial discretions, what people think before they lay charges. All of those things come into play, and we hope that we're one small piece of that by putting, and there is obviously a retention issue with women, particularly in criminal defense work, but when these cases come up, by putting that back on us, like, how dare you do your job? How dare you take on this case? How can you live with yourself? How can you do that? I reply, how could I not live with myself if we didn't do this work? And I think it paints us all with too much of a broad brush to say that, you know, that they're shocked that we're doing these cases, or that these men, because typically the accused are men, are hiring women to hide behind us. That also, in and of itself, is a myth and a stereotype, and is misogynistic when you think about it, because it assumes that accused are picking us as their counsel because we're women, and not because we're just darn good at our jobs. And everybody sitting at this table this evening is really good at our jobs, but we all get painted with the, oh, it must be because she's a woman, right? And that's hurtful too. And that's just completely wrong characterization of the work that we're doing and the importance of the work that we're doing.
Yeah. Well, ladies, I think that's good. I think we're going to wrap up, because we want to make sure that we keep these concise and make sure that the public who's hopefully still with us is understanding what we're saying and staying engaged. So Hamna, Maria, Megan, Natasha, thank you all so much for your time. And thank you to all of those who watched. We hope that you found this helpful and informative.
Thank you.
Thank you.
Mhm.